environment. Mahalo for your time and attention.
All right. Aloha and welcome today. It's our seventh session, and the way that it's our seventh season that we've done the Human Rights and Sustainability Campus Community Dialogues. And last month, we spoke a lot about the Universal Periodic Review and the focus on the United States of America. And excitingly enough, the U.S. will be reviewed on May 11th of this year. But before then, there's a whole lot of UPR diplomacy dialogues and country consultations, which we talked about last week. And I'm actually in New York working on those this week. And what we'll have is we'll have a meeting tomorrow at City University of New York with Columbia University, and we'll be coordinating as well with Hunter College and Roosevelt House to organize a series of diplomacy dialogues and country consultations in New York City that'll take place in March, on March 27th, as well as April 17th. But this week on Friday, besides the planning meetings in New York, we have the meeting at Howard University in Washington, D.C., as well as with the State Department on Friday. So we're focusing on the Universal Periodic Review. And one of the most important results of the Universal Periodic Review for the United States in the first cycle was the adoption of the UN Declaration on the Rights of Indigenous Peoples. And as many of you know, the to adopt that had voted against. And our guest today is from Canada, one of the other 4 countries that decided to wait a little while and change their vote. And Brenda Gunn is a Métis attorney. She got her JD from University of Toronto, and she now teaches at the University of Manitoba. She also has an LLM at the University of Arizona that has a great program in Indigenous peoples law and policy. But most importantly, I know Brenda from all of the amazing advocacy that she does at the UN, at the Permanent Forum, as well as a great intervention she delivers, I think that's quite noteworthy, at the UN Expert Mechanism on the Rights of Indigenous Peoples, otherwise known as MRIP. And Brenda's going to be able to share with us today and talk about the UN Declaration on the Rights of Indigenous People. But she's prepared a great PowerPoint that kind of thoroughly follows how Indigenous peoples have transformed the international institutions, and more importantly, what their Indigenous people are able to accomplish with the UN Declaration on the Rights of Indigenous Peoples, and where they're able to implement the UN system, as well as she has a lot of experience as well at the Inter-American Commission on Human Rights, looking at her work that she worked on in Guatemala. So very pleased to have Brenda there today, and she'll be able to speak to us about that. And then I'll be there to come in as well as she needs towards the end part. And we look forward to discussing Declaration on the Rights of Indigenous Peoples and its implementation today, as well as also an important point is the World Conference on Indigenous Peoples, which Brenda was also in attendance with on September 22nd and 23rd last year. Thank you, Brenda.
Okay. Experience. So thank you all for coming.
Why?
Yes. We have a small group, but I'm really appreciative for everyone to come and share their time with us today. As Josh said, what I want to do today is to do a short introduction to the UN Declaration, and then really start looking at the moving forward. What do we need to do today, and how to start realizing the rights that were guaranteed in 2007. So I do have a brief PowerPoint, and I believe it's all working in this, so everyone should be able to follow along. But I just thought I would very quickly provide a short context that the UN Declaration actually comes from a very long history of Indigenous peoples turning to the international arena to try to engage and move their problems outside of just sort of the state sphere. So we see in 1923, a Haudenosaunee chief from Canada traveled to the League of Nations, followed by a Maori leader. And then it was really mostly in the 70s when we start to see Indigenous peoples' issues begin to get some traction in the UN, and various issues and reports start coming out. And so, as well as sort of this work that began early on, we also have what the UN calls decades, where they sort of highlight various issues. Sorry, I'm going to stand. I feel odd sitting. We have various decades where the UN is starting to focus on Indigenous issues. So as part of its work in developing the UN Declaration, it was also engaged in other work to try to promote and protect the rights of Indigenous people. So they weren't just working on the UN Declaration, there was other issues. So the first decade was from 1995 to 2004, and then a second decade occurred because they had hoped the UN Declaration would be finished by the end of the first decade, but that was a little overly ambitious. So then a second decade was decided. That one's ending now, and so there's been talk and debate about whether or not a third decade would happen. So these are some of the goals that were happening, but I'm not going to talk too much about them. But as we talk about the UN Declaration, I think it's important for people to understand international law a little bit so that they can see where the UN Declaration fits within the broader world of international law. So we often have this divide between hard law and soft law. Hard law is all those binding treaties, customary international law. And people might have heard about various human rights treaties, the Convention on the Elimination of Racial Discrimination, the Convention on the Elimination of Discrimination Against Women, the International Covenant on Civil and Political Rights. There's other international treaties as well. There's the Kyoto Protocol people might have heard about, the North American Free Trade Agreement, all those free trade agreements. That's that hard law category. The other, in the hard law category, that's binding law that states are obligated to uphold. If states fail, there's usually some sort of mechanism in place that kind of court cases or other sort of dispute mechanisms exist. That's the hard law category. The other category is soft law. And this area of law is not as directly binding. States are still expected to follow that law. It's still law. It's just sort of not as enforceable on its own. It kind of needs other law to support it. And the range of what falls into soft law is really broad. And so the enforceability or sort of the weight of an instrument might depend on the type of soft law it is. So one of the sort of strongest types of soft law might be a General Assembly resolution. And that's where we have the UN Declaration falling in, is a General Assembly resolution. There's also declarations that come out of various conferences. There's reports out of all the various committees. So Josh was talking about the Universal Periodic Review. That'll release a report and talk about how the U.S. needs to fulfill its human rights obligations. So that kind of report that's talking about U.S. obligations, that would be soft law. So it's really broad, but what we start seeing is even though we have these categories of hard law binding, soft law not binding in and of itself, there's starting to be much more blurring or fluidity between the categories. And we see less of a focus on what is the type of instrument, but rather trying to understand more broadly the obligations that states have. So this is important, I think, when we talk about the UN Declaration on the Rights of Indigenous Peoples, because sometimes people try to say, oh, it's just a declaration, it doesn't mean anything. And I think that's really devaluing what the declaration was about and why the UN agencies and states and Indigenous peoples fought for so long to get it finished. So it does have weight, it's just not the same as, say, a human rights treaty that states are signing and ratifying, etc. So that's just a very brief background. And here's, just for your information, a list of the main international human rights instruments, and as well as some international bodies that have looked specifically at Indigenous issues or are included. So again, I'm providing this information so that people can understand that the UN Declaration doesn't exist as its own or on its own for protecting Indigenous people's rights, but there's a whole set of human rights instruments and mechanisms in place that Indigenous peoples rely on and that the UN Declaration is part of. So I like to show this broader infrastructure to provide greater context. So one of the things when Canada voted against the UN Declaration, they tried to say, whoa, we're not ready to have a vote at the General Assembly. This is moving too fast. And that argument for a lot of Indigenous advocates was really frustrating because, in fact, Indigenous peoples formally began drafting and arguing for a declaration in 1977 with that NGO conference. Okay, so if 30 years is moving too fast, I'd hate to see what slow looks like to Canada. So we start with an NGO conference in 1977, and then the first formal drafting from the UN process is the Working Group on Indigenous Populations. They complete the first draft in the early 90s. It then moves its way out to be approved by the subcommission. And then it goes on to the Commission for Human Rights, at which point the Commission on Human Rights didn't just accept the draft, but they formed another working group which continued to elaborate, and that process went on until about 2006, I think. And at the end, there were no sort of final consensus on the working group draft, and so the chairman did eventually draft a declaration based on his understanding of everyone's positions and trying to find some middle grounds. It then went up to the Human Rights Council for negotiation, approved, and then moved on to the General Assembly. But before the General Assembly finalized and voted on the UN Declaration, it went off to the third committee, and there were some additional side negotiations with various states and some Indigenous participation, although somewhat informally. Finally, in 2007, after 30 years, we have the General Assembly of the UN vote in favor of the UN Declaration, and so that's now our moment post-2007 that we're working on implementation. And one of our biggest moments after 2007 for implementation is the World Conference on Indigenous Peoples that I'll come and talk about in hopefully about half an hour or so. We'll get there, and we'll talk about what are we doing now at the international level to try to promote implementation. So as you can see, the process to finalizing the UN Declaration included many stages, and there was lots of opportunities at each and every stage for the UN and UN agencies, for states and Indigenous peoples to participate and try to articulate the rights. As I've already mentioned, the UN Declaration was a resolution of the General Assembly adopted in 2007. And while it's not technically binding because it's a resolution, it does have solemn legal effects and reflects the government's commitment to abide by certain principles. And one of the ways we sometimes articulate the binding or solemn nature of it is that when a country or a state decides to be a member of the UN, they have to sign on to the charter. And under the charter, members commit to upholding human rights, realizing self-determination, and are required to fulfill all of their obligations in good faith. That's a general promise that states make. And so a lot of us international lawyers argue that the UN Declaration helps articulate what are the obligations of states in relation to Indigenous peoples. The UN Declaration is setting out minimum standards, right? So the floors, the minimum, we can work up and make stronger articulations, but they're the minimum that states have to follow. I think very importantly, the UN Declaration recognizes the rights of individual Indigenous people, but also collective rights. And this was a huge advancement for international human rights. International human rights from the 1940s, when they first began being articulated under the UN, often focused on individual rights. And so Indigenous peoples' rights provided a bit of a complexity that the UN was not sure how to deal with. So we had some early decisions on self-determination that weren't very positive because the UN wasn't quite ready to wrap its mind around how human rights would be collective rights. And this was sort of by, the 70s and 80s when some Canadian groups and others went to the Human Rights Committee to argue for a right to self-determination. And the Human Rights Committee just wasn't ready to recognize that right, or didn't know how they could. And so by 2007, we have the international world recognizing that human rights can be collective rights, at least in relation to Indigenous people's rights. It's not about individual human rights in that sort of liberal way of thinking, but that it's actually broader. The UN Declaration also does not define Indigenous peoples. The UN recognized that it's not appropriate for the UN to actually define who is Indigenous and who is not. They left that to happen on a case-by-case basis, and I actually think that's a positive. We have all sorts of UN reports that provide some sort of context and information, but the actual definition can be far more fluid and flexible. And finally, I think one of the most important aspects to the UN Declaration is that it's recognizing these rights as inherent, meaning they're not granted by the states. So the UN Declaration is not the UN giving rights to Indigenous peoples, but rather recognizing Indigenous peoples' inherent rights. And so if rights are inherent, where are they coming from? Well, we can turn to Indigenous people's own customs, laws, and traditions to understand what those rights look like. And so for me in my work, that recognition of Indigenous laws and the role of Indigenous laws and customs and traditions to understanding rights is very valuable because it moves us away from sort of state law, Canadian law, American law, Hawai'i law, to actually looking at Indigenous laws to understand these rights. When you try to use the UN Declaration, I think it's important to try to know how to use it because it's a bit different than some other international instruments. And so I think it's important to try to interpret the UN Declaration in line and in relationship to other international human rights and other international instruments, because there's a lot that we can draw on and we want to make sure that whole body of law is moving together. So, when we're trying to understand the right to equality or what have you, you can look to some of the other international human rights instruments and try to see how they all work together to understand a right. But I think another way that I try to interpret the UN Declaration is to understand, why do we have this declaration? Why did Indigenous people spend 30 years at the UN trying to articulate their rights and get the UN to recognize those? And why did the UN engage in that process and the states involved as well? And so what I've pulled out on this slide are 3 of the preambular paragraphs from the UN Declaration that I think tell a very moving story. So the UN says that, why do we have a UN Declaration on the Rights of Indigenous Peoples? Because the UN is concerned that Indigenous peoples have suffered historic injustices as the result of colonization and dispossession of their lands. And for me, that's a huge win. The fact that the UN and nation states are recognizing colonization and dispossession has created injustices for Indigenous peoples is very significant. And so given the fact that colonization has resulted in historic injustices that continue to prevent Indigenous peoples from exercising their rights, the UN says they're convinced that if we recognize the rights of Indigenous peoples, it's going to enhance harmonious and cooperative relationships between the state and Indigenous peoples. But this relationship is now not going to be a colonial one. It should be a relationship based on principles of justice, democracy, respect for human rights, non-discrimination, and good faith. So the UN, I think, in this paragraph is saying a couple of really important things. One, it says that recognizing rights promotes harmony. I think in Canada, and I would argue in other states as well, there's often this fear-mongering that happens either by the state or other conservative groups, that if we recognize the rights of Indigenous peoples, that somehow that's undermining liberal notions of equality or undermining democracy, or it's going to tear apart countries. But in this paragraph, I think it says actually where colonialism exists, countries are already torn apart. And so if we want to fix countries and actually live in peace, then we need to recognize Indigenous peoples' rights, and we can no longer have a colonial relationship, but rather we need to have a relationship based on justice, democracy, human rights, non-discrimination, etc. So we have rights recognized because colonialism has undermined Indigenous peoples' rights. If we recognize Indigenous peoples' rights, it's going to enhance harmonious relationships. And so finally, the UN says if by following the framework provided in the UN Declaration, that we can have a standard to achieve, and that we need to pursue the UN Declaration in a spirit of partnership and mutual respect. Okay, so this needs to happen together. It's not up to the states to go out and implement the UN Declaration on their own. They don't get to decide what Indigenous peoples' rights to lands, territories, and resources look like. But states need to work with Indigenous peoples to articulate and protect these rights. So it's about working together in a spirit of partnership and mutual respect. Again, moving away from that colonial, the state knows best model that far too many states continue on. So with that sort of understanding of why we have the UN Declaration, we can then go on to try to actually implement the rights that exist in it. And the rights are really broad and all-inclusive. I have a list of rights up there. There's 46 articles. So we're going to watch a video in a second that explains the rights, but this is just one way to categorize the rights so that we can get a sense of what it looks like. I will probably, after the video, talk about self-determination, lands, territories, resources, participation in decision-making, and treaties. We'll see how the time's going. But those are sort of 4 areas that I work in mostly. So I just thought I'd give a flavor of what they look like. And now, if technology...
Article 1, Human Rights
Thank you.
and Fundamental Freedoms.
Article 2, Equality.
Article 3, the right to self-determination.
Article 4, autonomie et autogouvernance.
Article 5, Indigenous institutions, state participation.
Oh, Article 6, nationality.
Artículo 7, vida, seguridad, libre de violencia, protección contra genocidio.
Article 8, cultural integrity and prevention of cultural destruction.
Artículo 9, comunidades y naciones sin discriminación.
Article 10, free, prior, and informed consent prior to removal and relocation.
Article 11, cultural tradition and customs.
Article 12, spiritual and religious traditions, repatriation of remains.
Artículo 13. El propio idioma es fundamental para preservar la cultura. Se garantiza la participación en diversos procedimientos.
Article 14, Education and Our Culture and Language.
Article 15, Enseignement et information publique pour promouvoir la paix dans la société.
Article 16, Media and Cultural Diversity.
Article 17, Employment and Labor, Protection from Exploitation for Children.
Article 18, Indigenous Decision Making and Institutions.
Artículo 19, consulta previa con el consentimiento libre, previo e informado.
Article 20, Subsistence and Development in Economic Activities.
Article 21, Improvement of Indigenous Living Standards and Special Measures.
Article 22, Ensure protection for elders, women, youth, children, and persons with disabilities.
Artículo 23. Determinar y administrar el derecho al desarrollo económico y social.
Article 24. Traditional medicine and holistic protection of resources. Progressive realization of physical and mental health.
Article 25. Indigenous peoples have distinctive spiritual relationships with their territories and have responsibilities to future generations.
Artículo 26. Derecho a la tierra y reconocimiento legal de los sistemas indígenas.
Article 27. Due recognition of Indigenous lands and resources through fair process based on participation.
Article 28. Indigenous redress and restitutions for lands and resources.
Article 29. Environment, conservation and protection, prevention of hazardous materials, restoring health impacted by such materials.
Article 30, no military activities on indigenous land.
Artículo 31, patrimonio cultural, propiedad tradicional y propiedad intelectual.
Article 32, determine, develop priorities and strategies for resource development.
Article 33, identité indigène et citoyenneté basée sur la coutume.
Article 34, indigenous legal structures and customary practices in accordance with human rights standards.
Artículo 35, determinar responsabilidad individual en comunidades indígenas.
Artículo 36, contacto y cooperación, mismo si dividido por frontera.
Article 37, recognition of treaty rights and observation of agreements.
Article 38, national measures for achievement of declaration articles.
Article 39, access to assistance from states and international cooperation.
Article 40, dispute resolution and remedies based on indigenous traditions and customs and international human rights law.
Article 41, full realization of rights through cooperation and assistance from UN system and intergovernmental organizations.
Artículo 42. Promoción y aplicación de los artículos de la Declaración a través de las agencias especializadas de Naciones Unidas y del Foro Permanente para las Cuestiones Indígenas.
Article 43. The rights in the Declaration are the minimum standards for the survival, dignity, and well-being of the indigenous peoples of the world.
Article 44. Guarantee of gender equality.
Article 45. Nothing in the Declaration diminishes, extinguishes indigenous peoples' rights, now or in the future.
Article 46, respect for the UN Charter and promotion of principles of peace, justice, and human rights.
Okay. Oops, that's done. There we go. So that was just a video that was produced to have Indigenous peoples from all the world explain in a bit more of plain language what is all contained within the UN Declaration. So you can see that it's very broad, all-inclusive, really covers, I think, most aspects of Indigenous people's lives. As I said, I'll maybe spend a bit of time talking about some of the issues that I've focused on most in my work. But briefly, Articles 1 and 2 talk about equality and non-discrimination. So Indigenous peoples are to have the same rights as all other peoples in the world. And by same, I don't mean sort of identically the same. Everyone sort of has to, have the right articulated in the same way in that form equality sense. When we talk about equality, we're talking about substantive equality, and that idea that sometimes extra steps might need to be taken to protect someone's right in order to have an equal or just outcome. Non-discrimination means that Indigenous peoples aren't to be discriminated against because they're Indigenous or because they have these rights recognized. So just very sort of basic framework kind of ideas. And then Article 3, I think, is when it really gets going, and this is the right to self-determination. The right to self-determination, as people can probably assume, was quite contentious when it was being negotiated and was quite difficult to get agreement on. There was moments in time over the 30-year history where we got very close, and then consensus would start breaking down over various issues. But importantly, the phrasing of Indigenous people's right to self-determination in Article 3 mirrors the right to self-determination already recognized under Common Article 3, or the Common Article of Self-Determination in the International Covenant on Civil and Political Rights and the Covenant on Economic, Social, and Cultural Rights. And so here we can see that an interpretive approach that I was mentioning earlier, that we want to interpret Indigenous people's rights to self-determination in line with, or at least with a sort of understanding to how those other rights have been, or how the right to self-determination has been understood in those other human rights instruments. And it also means that we can't just say that Indigenous people's right to self-determination isn't binding and states don't really have to follow it, because of the fact that the wording so closely mirrors what already exists in binding human rights instruments. There's a very strong impetus for states to recognize Indigenous people's rights. So it is often said that self-determination is the foundational right from which all other rights flow. It's that right for Indigenous people to freely determine their political, economic, social, and cultural futures that we then understand all of the other rights. When we talk about the right to self-determination, it's important to think about gender relationships and that Indigenous women have a right to self-determination, so should also be included in any process that's going to articulate the scope of Indigenous people's self-determination. This is an issue that's been particularly poignant in Canada. Colonial process really targeted gender relationships among various tribes, and so we want to make sure that, it's not just the elected chief and councils that exist under the Indian Act, which are 90% men, that are determining self-determination and the rights, but we want to make sure that we include women as well as elders and youth in these processes. So another category of rights that was a significant win in the UN Declaration is the rights to lands, territories, and resources. And this, the articulation says Indigenous peoples have the right to own, use, develop, control, and strengthen their relationship with their lands. The right to lands includes lands which Indigenous peoples currently live on and use, as well as their traditional territories, so lands that they may have formerly used, but for various colonial processes have lost that connection. And it also applies to future lands that Indigenous peoples may acquire by treaties or other formats. So for one example here that I have on the side, the UN Declaration, how it works is that Canada, as one country, is required to work with the Indigenous peoples in Canada to set up a process to identify Indigenous peoples' lands, territories, and resources, and then protect those laws under Canadian law. So that we're going to look to Indigenous peoples' laws to understand what the lands are, what they're used for, etc. But that protection also has to exist in Canadian law so that the Canadian government can't just sort of brush them aside. In connection with the next slide on free, prior, and informed consent, when governments are looking at any activity that might impact Indigenous peoples' land, Indigenous peoples must be consulted. And so the next set of rights that I think is very important and very broad and all-encompassing is this idea of Indigenous peoples' right to participate in decision-making when any of their rights might be affected. So if the government is contemplating any kind of conduct that might impact Indigenous peoples' rights, Indigenous peoples should be participating in that decision-making process, right? It's supposed to stop that colonial relationship where the government is deciding for Indigenous peoples, but we're now supposed to be working together on these issues. How do we engage Indigenous peoples in this decision-making process? This is the standard of free, prior, and informed consent, or FPIC, that people might have heard about. So this idea that Indigenous peoples freely participate in the decision-making process, there's no coercion, that you either participate or we'll just go ahead and make the decision, or the government shouldn't be playing those divide and conquer techniques. So finding a group that agrees with the project and pitting that against other people who may have different concerns. So not coercing participation. And this can also include the difficult issue of financial incentives. So we always want to make sure that we compensate people for their time when they're engaging in these processes, but it shouldn't be financial incentives to sort of induce a certain outcome. So a very sensitive issue there as well. The timing of these consultations should be before the decision is made and without sort of a time constraint. We're not consulting the day before the government makes a decision and then say, okay, you know, tomorrow we're going to decide whether or not to clear cut this area or to start building a mine here. Do you agree or not? It should actually be far ahead of that process. And as in addition to timing, the government should provide all the information necessary to understand the ramifications of their decision. Right? So this could include making sure that Indigenous peoples have access to technical reports, as well as support to understand that technical report. So maybe the government needs to provide financial assistance to Indigenous peoples so that they can hire their own independent technical advisor to look at the impact on their rights. So free, prior, informed, and then consent is this idea that it should be a joint decision-making venture, that it's not about simply going in and saying vote yes or no, and there's not really a no option. It's really you go in and you should say yes. But actually this process of a joint decision-making process on the basis of free, prior, and informed consent means that Indigenous peoples actually can impact the decision and what the project looks like, and we're engaging in this process to try to arrive at an agreement. So this might mean the government may have to change their plans. Importantly, the UN Declaration also recognizes that Indigenous peoples' right to participate in decision-making should also follow Indigenous peoples' own process of decision-making. So this can be traditional protocols for however decisions would make, or however Indigenous peoples decide. So it shouldn't be the government saying, we're consulting you in this way, you come to this meeting at this time and you have to tell us an answer by the end of the meeting. It may actually require the governments to find out how an Indigenous peoples would come to a decision and follow such process. Again, we want to make sure that we're including women and where appropriate, elders and youth in the process as well. Maybe just a final set of rights is this idea of treaties, agreements, and other constructive arrangements. While this is a bit of a mouthful, I think it's important because it's very broad in what it's talking about. It's not just talking about formal treaties or instruments that we called treaties back in the 1800s or what have you. It can include other modern day agreements as well. So the UN Declaration says that these treaties, agreements, and other constructive arrangements are matters of international concern, so that the UN has an interest in ensuring and potentially overseeing the implementation of these agreements. And it also, the UN Declaration says that in certain circumstances, these treaties might have an international character. So it hedges a little bit on that position of, whether or not these treaties are actually international. It kind of says they could be international, which means they're not just, in Canada we call them sui generis, unique. They're not really like those other treaties we talked about, those human rights treaties. The UN Declaration recognizes they could be like normal international treaties. So a recognition that some of these agreements are actually state-to-state agreements, which is a significant win. The wording wasn't as strong as perhaps some wanted, but at least it's in there as a possibility that some of those treaties may be international in character. And then just finally, in case I haven't highlighted it enough, the UN Declaration recognizes that all rights are guaranteed equally to Indigenous men and women, and in particular highlights the issue of violence against Indigenous women, and that we need to work on addressing violence against Indigenous women. People may have heard about the situation in Canada of murdered and missing Indigenous women and the problem we have there. So one of the significant wins, I think, that occurred in the UN Declaration is recognizing the particular issue, and that we need to work to address it, in part that if Indigenous women are going to have or realize or be able to have the same social, economic, and political rights as Indigenous men, we need to address the potentially violent and unequal relationship that exists. So that's just a very brief sort of highlight of some of the rights that exist. As you heard in the video, there's a lot of others. There's a full range of cultural, economic rights as well. But again, that's not the area that I work in as much, so I chose to sort of highlight these as some of the main issues. But in 2007, after 30 years, we finally had the UN vote on the UN Declaration, and now I think becomes real hard work. That in some ways was the easy stuff, those 30 years of very tense negotiation. Now we have the difficult job of trying to implement the UN Declaration. And Josh and I have been working for a while trying to write a paper that shows the sort of need for a multi-pronged strategy where it's not just about states or the UN or Indigenous people who have the obligation to implement the UN Declaration, but it's really everyone. So at the international level, we have all of the UN agencies, we have these specific Indigenous mandates, so the permanent forum, the expert mechanism, and the special rapporteur. We have all the treaty monitoring bodies that are overseeing implementation of the various human rights treaties. all of those agencies have an obligation to ensure that their work is upholding and promoting the UN Declaration. We also see work happening at various regional organizations. So the African Commission for Human and People's Rights has done work that has looked at how, whether or not there's Indigenous peoples in Africa, and in fact they concluded that yes they are, and so the UN Declaration does apply and is relevant to Africa, and so the African Commission is starting to turn to the UN Declaration on the Rights of Indigenous Peoples when articulating and understanding rights in Africa. We also have the same thing happening at the Inter-American Court of Human Rights and Inter-American Commission of Human Rights. Those are the acronyms there under regional. We also have a whole host of organizations at the national level that have an obligation, I think, to implement the UN Declaration. I think domestic courts should be looking to the UN Declaration when articulating and recognizing rights of Indigenous peoples. It's a really important interpretive tool for us to understand what state law should look like. Legislation should also be compliant now with the UN Declaration, so every time a state is passing new law that impacts Indigenous peoples' rights, they should be turning and ensuring that it complies with the standards, the minimum standards, that are set out in the UN Declaration. NHRIs are national human rights institutions. So in Canada, we have the Canadian Human Rights Commission, for example, and they're starting to do some work on ensuring that they interpret Canadian Human Rights Act in line with the UN Declaration. It's a very slow process, but at least they're starting to undertake that work. And so I'm not sure actually, is there a national Human Rights Commission for the U.S.? I don't think there is there? I think there's various state organizations that, or states that have Human Rights Commission, and I worked with maybe one in Maine or something like that that's interested in some of this work. But I think another really important aspect where implementation occurs, I think, is actually education. And in my mind, this is happening from kindergarten, preschool, all the way up to university level. And so I'm always happy to go places and talk about the UN Declaration so that people can understand what it means and start recognizing what do we need to do to recognize and protect Indigenous people's rights, and try to take away some of that fear that exists with, what's going to happen in Canada if we recognize Indigenous people's rights will sort of all fall apart, and helping to try to alleviate some of those concerns. So I think education is probably one of the biggest areas where we'll actually see significant movements on implementation, because once people understand it, they're better able to then try to use it in their lives. And from that education, I think you can then move it to the political arena and start trying to get that political will within the state governments to start upholding it. And then additionally, we also have a role for Indigenous peoples and communities and tribes and to start upholding. So we have a few examples in Canada where various First Nations have actually adopted and start using the UN Declaration whenever they're writing their own laws. So I think tribal courts in the US should be taking the same approach of interpreting and ensuring that tribal laws also conform to the UN Declaration, because it becomes very difficult to argue that a state should follow the UN Declaration if tribal governments, for example, aren't following that same standard. Of course, we're not talking it's all going to look the same, but we need to ensure that we're looking to those minimum standards. So everyone has a role for implementation. Few examples. Another way of breaking this down, similar sort of slide, but just in a slightly different way. I think everyone from individual citizens who can go about sharing the information that they learn, to teachers, to corporations should be following it in their own codes of conduct. And so there's all sorts of ways that we need to start pushing for this. And although I'm a lawyer and focus on law reform and court work, I think if we don't have more work happening at the ground level, we'll never have it happen at the higher level as well. Okay, so that's kind of where we got to in 2007, talking a little bit of the work that we need to do now post-2007 to implement it. What I want to talk about now in closing is the World Conference on Indigenous Peoples. And so the idea for a World Conference on Indigenous Peoples came very early on in the process of negotiating it, but formally it was in 2010 that the UN decided that they would in fact hold a high-level plenary meeting of the General Assembly to be known as the World Conference on Indigenous Peoples, and this was held this past September. And so as soon as Indigenous peoples officially saw the resolution that yes, there was going to be a World Conference, the work began to try to ensure that any outcome document of the World Conference wouldn't undermine the rights existing in the UN declarations. So the goal for Indigenous peoples was to ensure that whatever happened at the World Conference was going to build and develop and sort of build on the UN declaration and ensure that there was no undermining it. So one of the big moments that happened was in June 2013, there was a meeting in Alta, Norway of Indigenous peoples, and this was called the Global Indigenous Preparatory Conference for the UN High-Level Plenary Meeting of the General Assembly, to be known as the World Conference on Indigenous Peoples. Like all things UN, it has to have an overly long, complicated. At the end of this 3-day conference, there was an outcome document that Indigenous peoples who were present agreed to, and this was now referred to as the Alta Outcome Document. And it was the Alta Outcome Document that Indigenous peoples then used as the basis for their negotiations with the states as to what the UN World Conference would look like. And so I have a couple of provisions just excerpted from the outcome document. So Indigenous peoples wanted to ensure that we're affirming the inherent rights of Indigenous peoples, and so Indigenous peoples needed to be able to participate in every stage of planning and then actually participate in the World Conference. Also wanted to ensure that the UN conference wouldn't undermine, as I said, the existing rights. And importantly, they wanted to ensure that the World Conference would affirm the inherent and inalienable right of self-determination, as it is preeminent and a prerequisite for the realization of all Indigenous peoples' rights. So that was sort of how they set up. And then Indigenous peoples suggested 4 basic themes that should be the focus of the World Conference. They suggested Indigenous peoples' lands, territories, resources, oceans, and waters as the first theme. The second theme they suggested was the UN system action for the implementation of the rights of Indigenous peoples. Third being general implementation of Indigenous peoples. And fourth, they suggested Indigenous peoples' priorities for development with free, prior, and informed consent. So they were trying to look at sort of how free, prior, and informed consent connects with development agendas. So that was the work that happened in June, a year and a bit in advance. After that process, we had the... Why is my slides not moving forward now? We seem to be stuck. Well, let's see if I go this way. That'll be a little cheat for us. So after the Alta outcome document, then the sort of process really began to really kind of move very quickly. So not a lot happened between 2010 and 2013. It was all very high level, getting the modalities and sort of trying to look at how Indigenous peoples would participate. But after the ALTA outcome document, we had the Indigenous Peoples Coordinating Committee working full-time in New York trying to promote the agenda and move things along. A couple of significant things that happened along the way. We end up with a consultation in June 2014 that the UN, the President of the General Assembly of the UN organized. We successfully advocated for the President of the General Assembly to not draft the outcome document on his own or just with states. And so for the first time ever, you had Indigenous peoples sit with the UN President of the General Assembly. That's usually a position that is restricted to high-level diplomats of various embassies. So we had two Indigenous advisors, Melzer from the Pacific and Myrna Cunningham from Latin America, who sat with the President of the General Assembly and helped draft the outcome document. The first draft of the outcome document was officially released in July. After that point, there were some consultations in New York where Indigenous peoples could sort of negotiate some of the language. There was 2 or 3 meetings that occurred. After that, we had the outcome document moved to just a state process. But even though it was formally just a state process, again, we had the Global Coordinating Committee there and negotiating with states sort of outside the room and trying to find the friendly states and find the states who would be willing to hold the line that Indigenous peoples wanted on the outcome document. So by the time the World Conference on Indigenous Peoples occurred in September, the outcome document was completed. This might be a surprise for people that the conference report, as it were, gets adopted the very first morning of the World Conference. It's all pre-negotiated and then just kind of rubber stamped at the meeting. But importantly set the tone. And so we have on the first morning in the opening plenary, sorry, here's Josh coming back. And we'll need to get the sound moved over to Josh for him to speak in just a moment. Hi, Josh. I'm just finishing talking about the World Conference. So we have the outcome document being adopted by consensus. I think that's very important. All the states agreed to the draft or the outcome document that had been drafted. We had the embarrassing moments again for Canada choosing to explain its vote and saying something about concerns about free, prior, and informed consent. It was very poorly looked upon by other states, and I continue to be embarrassed by my government and try to get them to take better positions. But it was very interesting to see Canada was sitting with the Holy See. That was our only friend that day. And Canada tried to tell me that they were the only ones brave enough to express their concerns, and I said, well, that or maybe you were the only ones not willing to have faith in the process and deal with those concerns later on. But so brave and fast. So brave and fast is what... Josh, you don't have your sound yet, so you're just talking to me right now, and I love it. So Canada takes its position. We then, after that opening plenary, then you moved into roundtables for that first afternoon and the second morning. You can see that Indigenous peoples weren't 100% successful in the themes that they wanted, but you can see similarities, and so I think that's significant. While the the fourth one wasn't development and free, prior, and informed consent, you could see that there was connection to the post-2015 Sustainable Development Agenda. We do have lands, territories, and resources. We have implementation and UN action. So I think actually Indigenous peoples were quite successful in setting out the terms for the UN, or the World Conference. And I'm just hoping that the tech guys can come out soon to get Josh and the Skype set up for sound so that he can talk in a moment about the optional protocol. But a couple of important things have now come out from the World Conference on Indigenous Peoples. One is that we're going to reconsider the role of the expert mechanism on the rights of Indigenous peoples. It's one of the 3 Indigenous-specific mechanisms of the UN. In trying to see perhaps what the role of the expert mechanism can be in oversight and implementation. We also have the Secretary General of the UN designate the Undersecretary General for Economic and Social Affairs as a senior UN official to coordinate the world action to improve the well-being of Indigenous peoples. That's another mouthful, but basically what we have is a senior UN official now that has the portfolio that's in charge of overseeing the action plan that was set out in that World Conference outcome document, because that outcome document really was trying to be very practical and say, okay, now we have this general framework of the UN Declaration. How do we actually begin realizing and actioning on it? So there's, it's a very action-oriented outcome. And then a third outcome that we see that's continuing is the work of the Permanent Forum on trying to look at whether or not there should be some sort of optional protocol that exists for and an optional protocol would be some sort of enforcement body or a body that could be created that you could bring complaints to. So some sort of body that's looking at implementation and potentially enforcement. And I don't know if I can move this if they're not I think it's just this one right here. Yeah, okay. We are a take charge kind of group here, Josh. Oh, that's okay. I think we've got it now. Josh, I think you're now connected, and I'm going to switch you over onto the screen now, and they should all be able to see you.
Okay.
So if you want to take over and talk about the meeting
Sure.
in New York in January.
Yes. So I was fortunate enough to be able to attend the UN expert meeting that took place just last month in January. And the main thing we were focusing on in January was coming up with a couple of papers written by different experts to actually look at and discuss and think what are some of the different ideas for initiatives related to the language that came out of paragraph 28 of the World Conference on Indigenous Peoples. So that was quite significant and very important to get everyone together. The interesting thing about it is kind of a good example of what was able to be done by Indigenous peoples with the Declaration. And I thought you did a great job at definitely pointing out the paragraph that recognized colonization and the harms that came from it. And really, if we look at what we're calling for in the future, that colonization would be replaced with cooperation. And with the cooperation, there was a new relationship, a relationship based on rights. And it's a rights-based approach to a future on how we're going to all live together and what way to move forward. And that's the strength of the Declaration. And now the Declaration, as you talked about quite well, I thought, discussing soft law, was also the idea that what came out of the meeting. So the meeting is another example of ingenuity, where Indigenous peoples are trying to create an optional protocol for a declaration. And as you talking about CEDAW and CERD, normally protocols only go to amend and add for individual petitions to those core treaty bodies. So the idea is saying we don't need to come up with the convention to start having an optional protocol to begin the dialogue where states can submit their record to the global community, and that there'd be a group of people that would look at that. So there are a couple of ideas, and I'll just talk about the structure a little bit so we make sure we have enough little time there, as I know 7 minutes is approaching. But the exciting thing, when you look at what they were talking about, they had a couple ideas. One is we'd follow the typical pattern now with 5 members from all 5 of the regions of the UN. But the other exciting idea was that the chair of the CERD committee, as well as the chair of the Human Rights Committee, on top of 3 other people would serve on the committee. So that was actually a proposal that was written by the Sami representative, Matthias Auden, that tried to propose that. And then you had the chair of CERD, Francisco Calle, who's also on the International Indian Treaty Council, discussing how, according to their mandate, they can't serve in 2 different roles at the same time. So it is a great example of, let's get together, let's try to get common positions, and then let's coordinate a strategy on ways to move forward, so that this World Conference that you're able to share wasn't just a 2-day meeting, but after the 2 days, it's implementing each one of those paragraphs from the document of the World Conference. So this is just paragraph 28. The other idea that came out that we're looking at, on top of the 5 reps and then having the optional protocol, was also looking at how we're able to then follow up with the Declaration on Indigenous peoples and be able to make that work. So it was interesting to see people sharing what are the different strategies, what are the different mechanisms, how it can be done, and then recognizing it's definitely being very innovative, and states that were, of course, there were very pragmatic. But at the end, they agreed that there should be meetings that continue, because this decision will have to take place before at the September session of the Human Rights Council. So there's really only 2 sessions. There's the March session and the June session, and then there should be some language that they agree on at the September session for the vote. So there's actually going to be a meeting, if people are following, from March 2nd through 6th in Geneva that will try to continue the conversation started in New York. So that's kind of where we're at with that. That's where it's moving forward. And that's the latest examples of this optional protocol expert group meeting that took place just on the 28th and 29th. It survived the snowstorm. It's kind of resilient like Indigenous people. Tuesday was canceled, but Wednesday and Thursday still took place. So as we know right now, there's still snowstorms all over the East Coast. So it's just a guess if you can get in and when you ever get to leave. But I did want to make sure that we're still able to do a follow-up and speak with you today. And I want to thank Brenda as well for covering all the points that she did. And if there's any questions from Hilo, or if anyone wanted to, I thought we should do that for the final minutes. And if not, we just thank Brenda very much. And the next session we'll have is Helena Nordberg Hodge on the 24th. And she'll be talking about the important issue of local futures as well as economics of happiness, speaking about her experience in Ladakh, in the Himalayas, in human rights.
Thanks. And I'm happy.
A little chilly here, though.
Yeah, it's cold here too, Josh.
I just wanted to do that to you once, because then you could like role play, because I know you never get to do that when people do that to you in Canada. So I want to make you feel good for that one.
Yes, I'm finally on the winning end of the weather debate.
How did that feel? Did that feel good to say that? Like in Hawaii, like, yeah, tough here too.
Yeah, that was fantastic. Good. I appreciate that. Might be my one only chance. I do have a question here in the room, and I think the system will switch and then you get on. I think this works. Okay.
Yes, coming from the hard law, there was treaties listed in there. Now, what about the treaties with regards to the treaties that were made in the development of the country? Are these sort of being discussed in this whole process of going back to seeing what was actually promised and didn't follow through?
Yeah. Okay, excellent. Yes, I'm being told we have 3 minutes, and I'm going to just switch you off for just off the screen for 1 second, Josh, because I'm going to I want to just go back to my slide here quickly, because I think that's an excellent question. I think that is what Indigenous peoples are advocating for, and what the UN Declaration is hinting at recognizing is that, in fact, if the treaties that were signed between Indigenous peoples and nation states are international in character, then they might actually fall into that hard law category, which would be binding on states, which are then part of their broader obligations. I think that was exactly the point that I was trying to make, is that they would be in there, and then when a state fails to uphold them, they're not just sort of failing their promises to Indigenous peoples, but actually failing to uphold their general or broader obligations to uphold all of their obligations in good faith, this idea of pacta sunt servanda, one of the sort of foundational principles of international law. Yes. I think we have about a minute and a half before they cut us off. Are there any questions for the other participants? Yes, I see one coming. Yep.
Gotta be quick.
I think, is the green light on? If oh, there we go.
The red light's on.
Oh, red light.
Can you hear me? This is from Hilo.
Yes, we can.
I just wanted to tell you that we're in the process of getting a CDAW agreement or whatever implemented at our county council for the island of Hawaii. You know, like San Francisco did and Los Angeles did. We're in the process of doing that now. And we wanted to try to have it all together for International Women's Day on the 8th, but I don't know if that'll happen. Another thing, we are co-sponsoring part of the Human Rights Film Festival.
Gonna cut out quick.
Human Rights Film Festival, which is next week. We are co-sponsoring 2 films about women on that. And that'll be on February 26th.
Okay, excellent. Thank you for sharing that. That's great work happening out on in Hilo. Thank you for sharing that. I'm going to say adieu. Good afternoon. We have about 4 seconds.
Aloha. Bye-bye.